Hi, my name is Santa Slockenberga, and today I'm going to talk about human germline gene editing in European perspectives, and more specifically, what would it take to enable human germline gene editing. Until 2018, human germline gene editing was thought to be still quite far from clinical reality. It wasn't so because the technique wouldn't be there that would enable these kind of interventions. There have been different techniques available for quite some time. Some newer ones, such as CRISPR-Cas9, are not only relatively easy to be used, but also affordable, and thus they create better preconditions for enhanced research and eventually care. It was rather because such interventions relate to artificially created heritable changes in the human genome, and they raise profound ethical, social, and legal questions that need to be resolved before this technology could be applied to human germline cells, either within clinical research or clinical care. In November 2018, about 3 years after the first use of gene editing technology in human embryos, a Chinese scientist, Dr. Ha Zhonghui, announced that he has helped to make the world's first genome-edited babies, twin girls who were born in that month. The world knows these babies as Lulu and Nana. The announcement that was made provoked shock, even outrage among scientists all around the world. The experiment that was made was deeply unethical, and given the availability of other means for preventing vertical transmission of HIV, which was the particular intervention that was done, they had little to no clinical justification. The international consensus that at this point it would be irresponsible to proceed with any clinical use of germline editing that scientists announced just 3 years before the intervention, that is in 2015, was violated. The critical reactions to the statement made by Dr. Ha Zhonghui are not surprising, and they were not surprising when they first came once the statement was made. After all, in a symbolic sense, human genome is regarded as the heritage of humanity, as affirmed in Article 1 of the Universal Declaration on the Human Genome and Human Rights. And any intervention in the human germline has a direct impact on future generations, and that needs to be given due regard under Article 16 of the UNESCO's Declaration on Bioethics and Human Rights before the intervention happens. And we know it had not happened. The technological developments that occur in the area raise high expectations for clinical applications for somatic gene editing and germline gene editing. They have the potential to shape the therapeutic landscape of genetically defined diseases and enhance the field of personalized medicine. And if the technology is shown to be safe and effective, clinical germline gene editing could have also distinct important benefits. There are two possible applications that are widely discussed. One is infertility treatment. Gamete gene editing could be an option for parents suffering from genetic infertility. The other option that is discussed is disease prevention in the future child, and it could be this technology could give a possibility for prospective parents who are at a high risk of, for example, having a child affected by a serious genetic disorder and for whom pre-implantation genetic diagnosis is not a real option, to be more confident they will have a healthier child. The technology as such, however, is not restricted to clinical potential only and could be used without any medical indication, such as for pure enhancement purposes. In the last years, several policy responses have emerged. And some of them are overlapping, others point in rather different directions. And just to illustrate, there are some who are suggesting moratorium on pregnancies from edited embryos, as human germline gene editing is not ready for clinical use. There are opinions that split on the continuation of research. Some suggest that research, in order to gain knowledge, should continue. Others emphasize that research should not continue as there is no potential for clinical utility, or the clinical utility is expected to be very limited. Although commonly it is emphasized that any translational research should be confined to therapeutic applications, there are also some rare voices suggesting that continued work should also be made in regard to possible permissible uses of human germline gene editing for non-therapeutic purposes. And there is rather a consensus that human germline gene editing is a matter of important societal concern and adequate discussions are needed. If the technology at some point is regarded as safe and effective and ethical dilemmas are resolved, can we apply this intervention in clinical research and clinical care? What does the law say? Well, if you look at the international fora, what we see is that human germline gene editing is vaguely regulated. We do not have an internationally binding treaty that would address the matter and would bind all the countries across the world. Only Universal Declaration on the Human Genome and Human Rights, in a rather vague manner, gives attention to the matter. In Article 24, it states that germline interventions could be contrary to human dignity. In Europe, both regional legal orders take a more stringent position. To begin with, the Council of Europe, in its Biomedicine Convention, has set forth a ban on introducing any modification in the genome of descendants, and it's intended to cover any intervention on gametes or on embryos if used for procreation purposes. It does not preclude carrying out research that does not involve procreation attempts. What's interesting with this provision is that this article doesn't rule out interventions for somatic purposes that might have unintended side effects on the germline. Those countries that have acceded to the convention are, of course, expected to follow this ban, and they are accountable for compliance. If we're looking at the European Union, then the question of clinical trials is a field of EU competency, and there the member states have been preempted from action insofar as the European Union has regulated the matter. Here, clinical trials regulation applies to all trials conducted in the European Union, and it requires that any trial is authorized in accordance with provisions set out in the regulation. And Article 90 says that no gene therapy clinical trials may be carried out which result in modifications to the subject's germline genetic identity. And a similar provision was enshrined in the old framework, the Clinical Trials Directive. On top of that, in the Charter of the Fundamental Rights of the European Union, in Article 31b, we can find prohibition of eugenic practices. What this really means and what implications it has for human germline gene editing is not fully explored yet, but it could have implications regarding the possibilities to rethink the legal framework. One could say that, and there are some who argue that bans such as those set forth in the Biomedicine Convention and clinical trials regulation sit very well with the principle of human dignity. But there are also some who argue that the very opposite is true. The principle of human dignity would require that interventions, if they are deemed safe and effective, are made available and alleviate humanity from suffering. And human dignity, among others, is a right set out in the Charter of Fundamental Rights of the European Union, Article 1. If we assume for a while that there is interest at some point and willingness to enable human germline gene editing in Europe to take place as part of clinical research or care, one could question how should we go about it? How, if at all, these bans could be lifted, and must both of the bans be lifted at the same time? So, and if you look at the Biomedicine Convention to begin with, it is an international treaty that is concluded under the auspices of the Council of Europe, and an international treaty may be amended by an agreement between the parties. The Vienna Convention on the Law of the Treaties, which is a treaty governing treaties, allows that treaty amendment rules are set forth in the treaty itself. So to say in Biomedicine Convention, and that is what is done. Article 32 sets forth a four-stage mechanism to make the amendments happen. To begin with, we need to have a proposal in place, and the proposal may come from a party of the convention, the Committee on Bioethics, or Committee of Ministers. Thereafter, it needs to be examined by the Committee on Bioethics. In this committee, each member state of the Council of Europe, and also the member state of the convention, should there be any who is not a member of the Council of Europe, may be represented, and each party who is represented then has one vote. If the proposal is approved, it proceeds to the next step, to the Committee of Ministers for their approval. And the Committee of Ministers is the organ that acts on behalf of the Council of Europe, and there each member of the Council of Europe is entitled to have one representative of the within the Committee of Ministers, and then each representative again is entitled to have one vote. And here there is quite a high voting threshold in place. If you look at the previous step, Bioethics Committee, there is required that 2/3 majority of the votes is in place. And then if you look at the Committee of Ministers, then what's required there is a 2/3 majority of the representatives casting a vote and a majority of the representatives entitled to sit in the committee. And only once these steps are passed, the text of the convention, the amended convention, may be forwarded to the parties for ratification, acceptance, and approval. In other words, one could say that there must be considerable interest in furthering the changes, and this interest needs to come from different directions and reach considerable threshold. Firstly, there needs to be a majority of the member states experts working at the Bioethics Committee in favor of the changes. Secondly, it needs to pass the threshold assigned to the Ministers of Foreign Affairs sitting in the Committee of Ministers. And only thereafter there is ratification, acceptance, and approval. So let's look at the European Union, what has happened there, and how could we think of lifting the ban within the clinical trials regulation. Clinical trials regulation is adopted in line with the ordinary legislative procedure. Any amendments need to follow the same procedure. This means that the European Commission holds the lawmaking initiative. The task of the Commission when initiating lawmaking is to promote the general interest of the European Union. And take appropriate initiatives to that end. In other words, only when the European Commission believes that lifting the ban on human germline gene editing is of the European Union interest, the Commission may prepare a corresponding proposal. Who is sitting in the Commission? Well, at this point, we have one representative per country, but it's required that they are completely independent and they shall neither seek nor take instructions from any government or other institution, body, office, or entity. Thereafter, once the Commission puts forward a proposal, it needs to reach an agreement between two central actors in the lawmaking procedure, the European Parliament and the Council. And that can take up to 3 stages. The European Parliament is composed of the representatives of the Union citizens, and it acts in the interests of these citizens. So to say, when the Parliament regards the intervention to be in the interests of the citizens, it's expected to act accordingly. And the Council also needs to agree, and the Council is the one who has policy-making powers within the European Union. And members of the Council are members from governments of the member states, and they are explicitly allowed to seek instructions from the member states. So to say, also the member states need to be on board in rethinking the ban set forth in clinical trials regulation. One could say that there must be considerable interest in furthering the changes, and this interest needs to stem from different directions and reach considerable threshold. There needs to be an interest from the European Union for this to happen. There needs to be support of the people's representatives and the member states. So, what does this picture tells us? Both legal orders set considerable thresholds for human germline gene editing to enter into the domain of clinical care. At the same time, neither of the two bans is set in stone. There are procedures for amendments that could be put in use, and these bans could be lifted. Similar to both processes, it's that they require considerable agreement between different representatives of the member states wearing different hats and those belonging to representing the involved institutions or people. There is room for tensions to emerge at the member state level and between different actors within the member state, and between different states and between different states and institution representatives. So theoretically, there is a possibility to lift the bans within each of the legal orders, and there isn't any requirement that it needs to be done simultaneously. It is, however, I would like to argue, neither practical nor sustainable from the state external accountability point of view that it is not done simultaneously. Council of Europe and the European Union share the same set of 27 member states, even though the total number of the members of the Council of Europe is 47. Not all member states are parties of the Biomedicine Convention, but a significant portion is. That risks resulting in a situation where a state has conflicting legal obligations. Some conflicts can be easy to resolve, some are not as easy to be resolved. For example, if the Biomedicine Convention lowers the standard and the EU retains it, then member states have a chance to envisage a higher level of protection, and that will be in line with the Biomedicine Convention. So this conflict could be resolvable. However, if the European Union lowers the standard, a question emerges whether it would then allow the member states to retain higher standards to remain in line with the Biomedicine Convention obligations. On the one hand, it's a question of moral values, where the EU has been generous in leaving quite some leeway to the member states. On the other hand, this matter will eventually end up being a market question, which then is of the European Union's interest. Additionally, considering the free trade and free movement, there could be rather limited effects of national unilateral exemptions, should they be allowed. And this could suggest that the question of human germline gene editing is a European concern, and we need fruitful multi-level policy discussions in addition to the dialogue with society and stakeholders. Thank you very much.